Good afternoon, everyone. My name is Barbara Kalarjan, and I am the Director of Development at the Diocese of Rockville Center. I want to thank you so much for joining us today for what we hope will be the first of many webinars that we will be presenting on estate planning. Before we begin, I just would like to get some housekeeping items out of the way. If I could have the housekeeping slide. This webinar will run for about 1 hour, and we will allow for questions at the end of the presentation. Your mics have all been muted by the moderator to avoid any distractions. You can submit your questions by typing them into the Q&A window provided on your Zoom toolbar, and we'll try to address as many questions as we can. You can also email me any questions that you would like answered. If at any point you're experiencing video or audio issues, please let us know by sending us a chat message. We also have a brief survey at the end of the webinar that we would appreciate you filling out so that we can better serve you. This presentation will be recorded, and we will send you a link in a few days. Now it's my pleasure to introduce Mark Henry. Mark has a background in law, accounting, and finance. An attorney and CPA for 30 years, Mark has been serving the Catholic community in these areas. He is the author of Finish Faithful, a book which explains how faithful Catholics can leave a lasting legacy through wise planning while helping their families and using tax-wise strategies that help the Church continue its important work into the future. Mark serves as a stewardship advisor to the Diocese of Rockville Center and its parishes, and his goal is to help our parishioners to finish faithful. Thank you, Mark.
Well, thank you for that introduction, Barbara. I appreciate the opportunity to participate in this webinar where we will be covering Catholic faith-based approaches to estate planning. And we are privileged to have some very qualified estate planning attorneys here joining us in the webinar, and they are going to be covering much of the content that we will be going over today. And I'd like to begin by introducing Vincent Russo, who's the managing shareholder of the Russo Law Group, a New York law firm which specializes in estate planning and elder law. They have 5 offices in Long Island and in New York City. And if I was to read all of Vincent's background qualifications and honors, I'd be here for quite some time. So why don't I just kind of leave it at he's an expert in this area. He's very learned and written extensively in the area of estate planning and elder law. And Vincent will be joined by one of his fellow attorneys, Marie Puma, and Vincent can take it from here.
All right, thank you, Mark. And it's really a privilege to be participating in this all-important webinar today, Catholic Estate Planning. And just on the bio side, what I am very proud of is being a legal contributor in the Legal Know on CFN Live. And actually, I'll be on tomorrow morning. And previously had my TV show, Family Comes First, on the Catholic Faith Network, formerly Telecare. And that's been truly a privilege, and it's allowed me to exercise and practice my Catholic beliefs and values. I'm thrilled that I'm here with my partner, Marie Elena Puma. She is a senior partner of our law firm, the Russo Law Group, with a particular concentration in trust and estate administration, special needs, and estate planning. And she's been recognized as a super lawyer since 2016 and has been with me, I think, roughly about 30 years. So she joined when she was just a young person coming out of law school. And so Marie Elena and I are going to be a tag team today. And what we're going to cover is what is a Catholic estate plan? What documents should I have as part of that plan? How to leave a lasting legacy. And we're going to spend a good amount of time on that. And then what are the next steps? And so we're going to just start with a broad commentary on, what is a Catholic estate plan? And for Catholics, doing estate planning and putting your affairs in order is an opportunity to provide for your family and leave a lasting legacy. And I know how important it is for Catholics, focusing in on family and legacy. Our Catholic faith should be reflected in the decisions that we make in our estate plan. First, we break it out into maybe 3 categories. The first being planning for family members. We have a Christian obligation to remember family and make provisions for their needs. My TV show is called Family Comes First. I'm a strong believer in this. We can provide for the basic needs, such as food, health, shelter, clothing, and make sure that, we pass a quality of life on to our family. But at the same time, as we think about leaving inheritances for family members, we're going to talk more about this later in how we do that and how do we do it without undermining our children's good character. Second, we can honor our faith in God by being good stewards of all that he has entrusted to us and our families, our faith, our very selves. This could include thinking about our Catholic teachings when it comes to making last decisions on important subjects like healthcare and our sacramental funeral wishes. And then lastly, third, we can provide for ongoing support for the church. There are a host of very worthwhile causes and needs that are out there, and we can support them using funds that would otherwise be lost through taxes. So your estate plan really provides a great opportunity to remember the church and leave an enduring, lasting legacy. As I mentioned, because I want to focus in on now a particular aspect of planning, which is, as we're faithful Catholic stewards of the many blessings we have, we should think about sacramental wishes statement. Marie Elena is going to get into these topics in more detail. But a sacramental wishes statement should be part of every Catholic estate plan. It clarifies important details, such as what you would want to receive the final sacraments, like reconciliation, anointing of the sick, viaticum, and apostolic pardons. Having Catholic medical documents dealing with healthcare issues, and making sure that they follow your respect of the life teachings of the church. And, we think about what our options are in these healthcare decisions, especially end-of-life decision-making. And there are alternatives to pro-euthanasia and pro-suicide. And it's important that you express in your legal documents how you believe decisions should be made. I mentioned providing for family and really our Christian obligation to do so, but also taking the values that we have and broadening it out beyond just family, but for our communities, for our parishes, for the family, friends, and greater community. And then leaving a lasting legacy, so important, because we can provide ongoing support for the church. And as I mentioned, a number of ways that you can do that. So having a Catholic estate plan goes beyond just estate planning. It's making sure that our beliefs are incorporated in what we say and do in our lives and then beyond. Now, with that as a backdrop, I want to pass it on to Marie Elena, who's going to focus in on the healthcare issues and decision-making that goes on. And then I'll come back and talk about your assets, how you leave your property, and how you can help the church. Marie Elena?
Thank you, Vincent, and welcome everyone. So as Catholics, we are very fortunate that the church provides guidelines to us with regard to end-of-life healthcare decision-making. So I'm going to go through a couple of these with you so that we can take a look at them and just be very clear about what the church teachings are on end-of-life decision-making, euthanasia, and other issues. So in 2009, the United States Conference of Catholic Bishops published the Ethical and Religious Directives for Catholic Healthcare Services. And basically this publication, in this publication, the bishop stated that we are obliged to preserve life. And if somebody is hospitalized, they are entitled to life-sustaining care. So that's what we have there. Then we have the Gospel of Life, which was the encyclical letter of Pope John Paul II. And in that, Pope John Paul, this was a landmark writing where he made it very clear that the Catholic Church condemns abortion and euthanasia and challenges those who take part in a network of publicity and that support the crimes against humanity. So that is something that Pope John Paul II said, and I believe that was back in the same time frame. Then we have the Catechism of the Catholic Church, section 2280, and that basically says that we are stewards of God. God provided us with life. We don't own the life. God has entrusted the life to us, and therefore we must make sure that people receive nutrition and hydration as basic ordinary care. Food and water, even if it's provided in an artificial way, medically provided, it is something that we are entitled to, and that it is not up to us to decide life and death. This is a life that is given to us by God, and God is in control. We also have the Sacramental bonus, the Congregation for the Doctrine of Faith, and that basically is a Catholic teaching that talks about the care of persons in the critical and terminal phases of their life. And within that publication, which was approved and affirmed by Pope Francis in 2020, basically says that nutrition and hydration are considered ordinary and basic care and are necessary to maintain physiological functions. Unless there's no benefit to the body, meaning that the body can't absorb or metabolize the food and water, and it would cause harm. So it is very clear from the Catholic teachings that we must respect life, we must preserve life, we must promote life. So it is very important that we keep that in mind when we put together the estate plan, okay? So when we look at your healthcare wishes, so thank you. We need to follow the church's teachings, which we just talked about with the sanctity of life. So we have to have a couple of things. We need to have a Catholic medical directive that follows the Catholic teachings, and we're going to look at these documents one by one as we continue. You need to have a healthcare proxy that's consistent with Catholic teachings, and we also just put, a little note out there that you have to take a look at living wills, because often they'll have provisions in there that may not be consistent with Catholic teachings, and they may be viewed in a way that they could promote euthanasia. Okay, so we're going to look at those documents a little closer. So we have to make sure that we reflect our Catholic faith in our decisions. So we're going to look at these documents one by one, and they're also called advanced directives because you are planning in advance. When you are well and able to make decisions and be in control, you're going to determine who can assist you in the event that you can't assist yourself or can't make decisions for yourself. And then how do you place what those instructions are in, for example, a Catholic medical declaration? And we're also going to look at, that is not on this slide, we're going to look at the burial designation in New York, which is the appointment of an agent to make decisions with regard to the disposition of remains, and also the sacramental wishes statement. So we're going to take a look at those together as well. All right, so we're going to look on the next slide. We're going to focus on healthcare proxies. So I'm sure all of you know what a healthcare proxy is, but just in case, a little bit of a refresher is you're in control, you're making decisions when you're alive and well, and you're able to determine who will be able to make healthcare decisions in the event that you're unable to do that for yourself, okay? In the event that you lack capacity, who do you trust to make those decisions on your behalf? So it's really important to be in control to be able to determine who you want that person to be. Often it's your spouse or a child or a family member. Sometimes it's a friend, and sometimes, you know, it may not be the, you know, typical person that we ordinarily would think, you know, you would pick. Sometimes I've had clients who don't pick their spouse. They don't want to put their spouse in that type of situation, and they don't feel that their spouse can make those decisions. So it's important in this document that it provides for ordinary care. That basic obligatory care that we just talked about in the Catholic teachings, the guidelines that we have seen from the church, which is food and water, whether it's assisted medically or the person is able to feed and drink on their own. Painkillers as well. In this healthcare proxy, you're directing your agent, and you could appoint a successor agent if your agent is unable to act, to make healthcare decisions according to your moral values and your religious beliefs. So within that document, you're going to make sure that it is clear that you do not desire any act or omission that will directly take your life, that you want and you desire life-sustaining care, including intravenous nutrition and hydration. So it's very important that your agent knows your wishes and that they act in accordance with those wishes. It has to be somebody that you trust. Now, a healthcare agent has to, by law, act in the best interest of the principal, the patient, to preserve your health and your life. Okay, so it's very important that you select somebody that knows what your wishes are. Now, in the event, and it happens sometimes, that a person does not have a healthcare proxy, New York State has the Family Health Decision Act, which was passed in 2010. And basically, it applies to when a person is in a hospital, in a nursing home, or is receiving hospice care. And if they don't have the capacity to handle their healthcare decisions themselves, and they don't have a healthcare proxy, New York law basically allows for a family member or a close friend to step into the shoes as a surrogate to make those decisions for the person. But it's always better off to do the planning in advance so that you can be in control and pick the people that you want to serve in that capacity. Okay, so we're going to move on to the Catholic Medical Declaration. And in New York State, who has the right to make these life-sustaining treatment decisions? So in New York State, New York presumes that you want all life-sustaining treatment. So it is very important as a Catholic that you have clear and convincing evidence of what your desires are. And to do that, you can do that in a Catholic medical declaration. Now, this is not the same as, it's what is intended to be what some people call a living will, okay? But we're not going to call it a living will because, again, we talked earlier that sometimes in a living will, there's provisions that might be contrary to our Catholic wishes and our teachings. So we call it a Catholic medical declaration, and it provides those instructions to your agent under your healthcare proxy about the life-sustaining treatment that you want and under the conditions which you want that treatment, okay? Which is food and water. It's a moral obligation under the Catholic Church, as long as if your body is able to absorb and metabolize the food and water without causing any harm to you. So what should your Catholic medical declaration say? One, that you want to receive ordinary care. Again, this is morally obligatory care. It's food and water, even if it has to be done through medical assistance. You want to preserve life. You do not want any acts or any omissions of euthanasia or suicide. We're stewards of God. God has given us the gift of life. We don't have the ability to take that away. We also want to include in that declaration that you want to receive the healing sacraments of, as Vincent mentioned earlier, reconciliation, anointing of the sick, viaticum, and apostolic pardon. Okay, so that's very important. You're not going to see that, you know, in the, what I'll call the secular living will. Okay, so the next document I want to talk about is the HIPAA authorization. And I'm sure all of you are very familiar with HIPAA. But basically, this is the authorization that you, we prepare a separate document. It's very comprehensive that allows your agent to access your medical records so that your agent can act in your best interest and have access to all the medical information that's necessary for them to make informative decisions about your care. Okay, so this is something based upon the law, and basically it allows access to medical records to your agent so that they can act on your behalf and in your best interests. The next documents that I want to talk about are the document under New York law that I'm going to call burial designation, but it's an appointment of an agent to have the authority to dispose of remains upon death. So this burial designation is New York state law, and it allows you to appoint an individual and a successor or alternates after that person to be the person in charge of making your funeral arrangements. There's provisions in that New York document that allow you to put in what your wishes are. And our clients do that, but it's also very important to do another document in conjunction with this, which we'll call the Catholic component to this document, which is under New York law. We're going to talk about that in a second. I want to stress here the importance of this document because I often see provisions in somebody's will that says what they want to do, what they want to happen when they die, you know, where they want to be buried and what they want. And unfortunately, by the time that will is offered for probate, accessed, reviewed, it's after the person has passed away and likely after all the arrangements have been made in the burial and so forth. So the will, your last will and testament is not the place where you should put this information, okay? So you definitely should do a burial designation under New York law so that you appoint the person who will be able to make those decisions and successors to that person. But what you also need to do is a sacramental wishes statement. And a sacramental wishes statement is something that our priests love because it's really helpful to them and it's helpful to the family so that the Catholic person who has passed away is going to receive the sacraments. The person is going to have the proper funeral rites and burials that they want. So this is a very, very helpful document. It gives direction to the family and the pastor about what your wishes are. So in this document, you include the name of your parish, the name of your parish priest, and contact information, and your wishes that you want to receive once you become ill, reconciliation. You want to receive the Eucharist. You want anointing of the sick. You want an apostolic pardon if you're unfortunately, you know, close to passing. You include there the name of the family member or the friend that you want to be able to assist in making the arrangements for you to receive these sacraments before you pass away and for you to have the funeral rites and Catholic rites of burial after you pass away. You could appoint a family member or friend, and then you could appoint a successor and so forth. You can include very specific directions in this document about your funeral, including the vigil service, the wake, the eulogy, where you want it to happen, the funeral mass details, the music, the readings, the scripture, the burial details, the cemetery, etc. So you can be extremely, extremely specific in terms of what your wishes are so that it makes it very easy for your family to carry out what you want. So altogether, the healthcare proxy, the Catholic medical declaration, the HIPAA authorization, the burial designation, the sacramental wishes statement, all of these documents together allow you in advance to be proactive while you're still able to control what your wishes are and to ensure that these decisions are going to be made in accordance with your religious beliefs, your moral values, and the teachings of the Catholic Church. So at this point, we're going to go back to Vincent, and he's going to talk about another advanced directive on the financial side, not on the healthcare side.
But before you leave, I have a couple questions for you. Would you suggest attaching the sacramental wishes statement to the burial designation and keeping them together?
Yeah, I would definitely keep them together. And like I said, the burial designation has an area in the beginning of the document where you can put some of your basic wishes there. I would put some of those wishes are, and I would also reference in that location that you also have a sacramental wishes statement so that they know to look for that and keep them together.
Marie Elena, where should one keep these documents once they've been signed?
Yeah, so very good question. Where you should not keep these documents is in a safe deposit box at like a bank or a financial institution, because these documents need to be easily accessed. So you should keep them in a safe place in your home, maybe in a fireproof safe, something, and let your family members know where those documents are and where they can access to them. If you also, work with an attorney, you can set up a secure Dropbox where those documents can be easily accessed online with great security, so that 24 hours a day, 7 days a week, your documents could be accessed if necessary.
Yeah, I think the key that you mentioned here is that one should communicate with a trusted family member where you're storing these documents. And it may make sense to perhaps execute 2 originals of each of these documents if you're going to leave a set, say, with a family member or with your attorney. So just thoughts on the practical side.
Yes.
Thank you so much, because this is a real eye-opener for me as a Catholic in that there is a lot here to think about, and in terms of these all-important documents, because we're all living longer, and with medical technology, a lot of challenges out there in terms of how we view life and the quality of life, and being reverent to our Catholic beliefs.
So true.
So thank you.
Thank you.
So I'm going to, as Marie Elena mentioned, I'm going to move into the financial side. And as she said, she spent a good amount of time on what we call medical advanced directives, the healthcare proxy, the Catholic medical declaration. So what about dealing with assets? Your bank accounts, your real property, your brokerage accounts, if you have one, retirement accounts. What about paying bills on an ongoing basis and managing and investing your assets? If someone loses the capacity to do that, what happens? So now it becomes a legal issue. And if you lose capacity and you have no planning in place, you and your family are going to be stuck, quite frankly, with the inability to do these managerial investing activities. And so this could be incredibly detrimental to family if your utility bills aren't being paid, or you're not filing your tax return because no one can sign it, or you're not managing your brokerage assets and the stock market is so volatile and you're not able to respond to it. So everyone, along with the medical advanced directives that Marie Elena referred to, those healthcare directives, everyone should have a durable power of attorney. A durable power of attorney allows you to appoint another person who can act in your place as to financial matters, such as paying bills and managing your assets. You can name multiple agents at the same time. You can provide for them to act jointly or separately. You can provide for successor agents. The key here is to appoint someone that you trust. That's the most important decision you're going to make in terms of giving this authority to another person to be able to step in and act on your behalf. And as I mentioned, the power of attorney is used when you lack capacity. It's a revocable document, so you could change it anytime you want. The other key is to have the document outline the different powers that you're giving to that agent. The ability to manage your bank accounts, to pay bills, sign tax returns, open your mail. These are all activities you would want to provide in your power of attorney document, so that person can really step in and take over, and they always have to act in your best interest, just as Marie Elena mentioned on the healthcare side. So to me, these are critical documents that we've just discussed with you. They impact your life, your quality of life, and also impacts the future of your life and family. So that having a plan in place to take into account that at some point, it may be that you may not have the capacity to make those decisions. Now, we also want to talk about today, how do you plan for the transfer of your assets to family members when you pass away? And there are several different ways of being able to do this. One is through a last will and testament. So everybody's familiar with a will, last will and testament, wherein you name an executor, a person to be in charge of your estate, and to list and provide for in that document how you want your assets to pass. To whom do you want those assets to go, and in what manner? It may be that you're leaving assets outright to family members, such as spouse or children. It may be that you want to have those assets held in a trust for that family member in a more protective way, perhaps because they're a minor, and so holding it in trust makes sense. Or perhaps they have issues in terms of managing their financial affairs or other types of issues that would adversely impact their ability to really make the right decisions for themselves. And so having a trust under your will can be a protective step in those situations. Or if someone was to receive an inheritance and unfortunately had a stroke and now are not able to manage, you can have a contingent trust, a trust under your will that says, if a person is disabled, then we want to put it into a trust so that they can maximize their government benefits, and those assets can be properly managed and used for the benefit of that individual. Now, when you have a will, it's subject to probate. Probate means that you have to file the will in the surrogates court in New York. And basically, you're asking the court to approve the will. In effect, the court will appoint an executor and say that this will is valid under New York law. And so the executor should follow the terms and provisions of that will. So that's a probate proceeding. And most individuals, when they do estate planning, have a last will and testament. But we're going to talk about another alternative here, which is a revocable living trust. And we learned from this COVID pandemic that in a crisis situation where, unfortunately, so many people passed away, and it was a crisis in the community, so the courts literally shut down. There was no opportunity to probate a will during that time period. And so assets are frozen. No one has access to them. They're not available to pay for bills or funeral expenses until a court approves that will and appoints the executor. So a revocable living trust is another alternative where you can sign a trust document today. You would be the grantor, the person setting it up, and you could also be the trustee. And this is a revocable document that you could change at any time. And that document can allow you to provide for your family like a last will and testament. It can say that when you pass away, so-and-so is going to step in as the successor trustee, and I want my assets to be managed and distributed in accordance with the trust provisions. Here, there's no court proceeding. There's no delay in accessing those documents. So a revocable living trust can be a wonderful alternative in terms of how you manage to pass your assets to your family when you pass. But also, while you're alive, you can fund that revocable living trust. And that's critical to avoid that probate proceeding. So you actually have to take the deed to your house and retitle it to the name of the trust. Nothing changes. You're still the owner. You still manage and own that house, and no one has a right to that house or a right to live there other than you. So you would fund it with assets to avoid probate. Now, there are two other ways you can avoid probate that I want to mention. One is a beneficiary designation. So, for example, you can have a bank account with a pay on death statement naming another individual to receive your bank account upon your demise. You can do that with life insurance, naming a beneficiary under your life insurance policy. You can do that with IRAs and your 401k plans or 403b plans. So your retirement accounts, you can name a beneficiary. And in most cases, that will make a whole lot of sense. And in some cases, you actually may want to name a trust to receive those assets. If in the examples I gave before, you want to leave it in a more protective way. The other way you can avoid probate is to hold an asset joint with right of survivorship. So you can have a bank account which is named in your name and your spouse, for example, with right of survivorship. And so if one passes away, the other becomes an ongoing owner of that account 100%. And so there's no delay or need for probate. So these are the situations when we meet with clients and we're planning their estate that we want to talk about. What assets do they have? How are they owned? Do they have beneficiary designations, or are they jointly owned with right of survivorship? Would you like to approach this with the revocable living trust, which can avoid probate and make it easier for your family later on? Also can reduce the legal fees? Or do you want to have a will and understand that it'll be subject to probate? All right, so on just a quick summary here of the will, one last time. It provides for the administration of your estate and the orderly disposition of your assets upon your demise. It has to be signed with proper will execution formalities. So you want a lawyer to really draft your will and supervise the signing. You cannot change your will by writing on the original. That's just a tip. that if you have an original will and you wake up in the middle of the night and want to change it, you cannot do it that way. You would need to have either a codicil signed with certain requirements, or you can execute a new will meeting your desires. So you cannot handwrite a will in New York as a general rule. So that's also something do not attempt. It will not work. And if you do not have a will, New York State does have a pecking order of who will inherit your assets. And it's basically done in a way that it's closest in line from a bloodline standpoint. But you don't want to leave it up to New York to tell you how your assets should pass and to whom. So if you have a will, just think about whether you've met the requirements, have had it drafted by an attorney who supervised the signing, and that you haven't changed it in any way. If it's stapled, do not unstaple it. That could cause an extra proceeding in the surrogate's court and potentially lead to it not being validated by the court. All right. Now, I mentioned the revocable living trust as a way of avoiding probate and passing your assets on. But there are other types of trusts that can also be very helpful. And I just want to mention a couple. One is a Medicaid Asset Protection Trust. Now, why would I want to consider this type of trust? This has to do with long-term care, which we all know can be very, very expensive, especially in a nursing home setting, and especially living in New York and on Long Island. And so the only government program that is available to pay for long-term care at home or in a nursing home is Medicaid. And Medicaid is a financial eligibility type program. You're not automatically eligible like you are for, let's say, Medicare when you reach age 65. And so your assets that you own in your name will prohibit you from accessing the Medicaid program for long-term care. So there is a type of trust where you can place your assets into that trust. You can retain the right to live in your house if you transfer the house to the trust. And as a general statement, after 60 months, because there's what's called a 5-year look back for nursing home care eligibility, those assets won't be counted against you if you needed to go on the Medicaid program for nursing home care. So no one should lose their home because they have the wrong illness and they need long-term care. The wrong illness is Alzheimer's, ALS, Parkinson's. These are diseases that you need assistance with activities of daily living, and unfortunately, Medicare does not cover it. Also, these assets can be placed in a Medicaid Asset Protection Trust, and under current law, there's no waiting period for eligibility for home care services. And that's where most people want to live. They want to live at home. And so by transferring those assets into that type of trust, they'll be able to access the Medicaid home care program. The other type of trust we talk about with our clients is the Family Protection Trust. And the Family Protection Trust is a trust that would be the receptacle for leaving assets for family members in a most protective way, so that later, if there are issues in terms of marital issues or issues in terms of that person being a spendthrift, or they have issues with alcoholism or drugs, having a family protection trust for that family member or for the family members across the board can be so protective. And so we talk to our clients about these options. What's great is their tools in the toolkit. And so which are the right tools to use depends on your particular situation, what you're trying to achieve, how you want to leave a lasting legacy. And that gets me to a discussion about your legacy. And I talk to clients about how do you instill values in your family, especially your children and grandchildren? How do you take your Christian Catholic teachings and beliefs and instill them in a way that on a day-to-day basis, you're practicing your faith and your children and family members are also doing the same? So legacy planning is how you want to not only transfer assets, but how you want to be remembered and what was important to you that you would want to pass on. And so as part of legacy planning, we also want to remember the church. And there are a number, and so we want to give back for all that we've received. And we want to practice our Christian beliefs by supporting the church. And so it can expand beyond just my giving money to another individual in a helpful way. So legacy planning gifts, you can do it through your will or the revocable living trust that I mentioned. So you could say in your will, I'd like to leave X dollars or X percentage of my estate to the church. You can do it through IRAs, retirement plans. You could do it through an insurance policy. Parishes are looking at creating endowments, or they have endowment funds. And so we spend so much time benefiting from our parishes and the people in the parish. So it's a way of giving back by supporting the parish. You can, on a bigger scale, think about setting up a private foundation or setting up a charitable trust. And a charitable trust allows you, depending on how it's structured, to keep an income stream and then leaving the remainder upon your demise to the church. There are a number of different techniques and strategies that can be utilized when we're looking at gifting. And there are tax benefits that can be achieved by implementing this type of planned giving. So not only can you help the church, but you can also save taxes. And that could also lower or avoid legal fees and court costs later on. So planned gifts can be very helpful to you. And we have to consider, your needs when I meet with a client. What are your needs? What are you able to do? How do you feel about helping others? And then we create an appropriate plan. So let me just touch on one of the strategies that's out there. It's a legacy plan with IRAs. And what's great about planning with IRAs is that you all know how wonderful IRAs can be in growing your estate, your retirement account, because the assets in a traditional IRA grow income tax free. But when you pull the money out, it's subject to income tax. So one of the things you can do to avoid that income tax and help the church would be to name the church as a beneficiary of your IRA or your parish endowment fund. And that way you're bypassing income taxes. Your family's avoiding the income tax on an inherited IRA. And you can give part of your IRA or all of your IRA. You have flexibility there. And you can arrange it in a way that the gift is only after you and your spouse pass away. So that if you want to retain control and you have a need for those funds or a desire to have access to them during your lifetime or your spouse's lifetime, that's fine. So there are a number of different strategies here with IRAs that can be very helpful. And so let's take a simple example that if I wanted to leave $10,000 to the church, if I'm not thinking about this strategy, I'm going to leave $10,000 of an IRA to a child who's going to pay tax at 30% and end up with $7,000. And in the alternative, I could have left $10,000 from the IRA. The full $10,000 benefits the church, and that child receives $10,000 of another asset without having to pay the income tax. So definitely worth considering. And right now is the time of year. You know, we just had Happy Thanksgiving. We're moving into Advent season and then Christmas. It's year end. So if you want to take advantage of getting a charitable deduction for your income tax return, now's the month. The month of December is the time to do it. What happens if you don't have a plan? Well, you lose control over your personal life. I'm so saddened when we have families call us in crisis and there's no plan at all. They don't have the documents Marie Elena talked about with healthcare. They don't have the financial documents that I've talked about. And literally, you lose control over your personal life. You potentially could lose your assets and you could lose access to needed long-term care. Everyone should have a plan in place. So what do you do about this? Well, you act. You create a plan now. I would urge you to retain professionals, an elder law, special needs, or an estate planning attorney to assist you, and then understand what is available to you, come up with the plan, and then the key is to implement it, to make sure that you actually take the steps. Not, I'll get around to it next year or the year after, or when some event occurs. Have a plan in today, do it today. You can always change it in the future. Life changes, your plan's going to change. So it's just life is fluid in that way, and we need to be open-minded about the planning. So with that, we've given you a tremendous amount of information. I hope it's been helpful, and we'll see if there are any questions. So if someone can let me know, because I am not seeing any questions at the moment. Join me, Marie Elena.
Yes, I don't see any questions either.
Well, I want to thank Marie Elena for being so clear in everything that she presented. And so I think we have a few more minutes. So I would like to just talk about my growing up in Brooklyn in the 1950s and early 60s. And I would wake up on Saturday morning and tell my mom, and my mom, I had, when I was younger, she had about 6 or 7 of us. She ultimately had 8 of us. I would say, Mom, 7:30, I'm leaving. I'll be back later. And she would say, okay, be home by 6 o'clock and don't be late or else you're going to be in trouble. I won't tell you what she also said about trouble. And so I would get on my bicycle and I would ride away at 6, 7 years old. And I would go out and play with my friends for 8 or 9 hours and come back home always by 6. And so life was simple. And then I'm in the 1980s and I have a few kids, little kids, and my wife says I got to go to Macy's, and I head to Macy's. And for a brief moment, I have my little one, Robert, disappear in the clothing part of Macy's, and I am freaking out. And he was out of my sight for only a couple seconds. He was hiding in the clothes, playing with the other 2. And so I think about how simple life was growing up for all of us who remember those days. And then I listened to Marie Elena today. And I said to myself, oh my goodness, you know, life is complicated. There are a lot of challenges. We're all living longer with health issues and financial issues. We're so tied in with the whole world and world events that we stress out and have anxiety attacks. And I think about all these documents Marie Elena mentioned that no one did these documents in the 1960s. And perhaps many of them didn't even exist legally. But I know for sure from our experience, having met with thousands of families through the years, that Marie Elena and I can attest that families are so much better off when they have a Catholic estate plan in place and that they're not calling us in crisis. And so I just want to end with that because I just can't emphasize it enough. We did get a question.
Yeah, we have one question, Vincent.
From Doreen. How involved is it to set up a Medicaid asset protection trust and a family protection trust, costs and time involved? I would say you have to make a commitment to implementing trusts. So it's going to take some time. There are going to be some questions the lawyer is going to need answers to. They're going to need to understand the bigger picture. And so I think it's a commitment on the part of you, the individual who wants to implement the plan. The attorneys can get it done fairly quickly, especially the experienced ones, so that, you know, if there was an urgency to having a trust put in place within days or a few weeks, it can be done. And so the process really starts with sitting down with the lawyer, understanding the pros and cons of a Medicaid asset protection trust and a family protection trust, understanding your values, your situation, your assets, understanding who you trust that you might name in the document, who you want to leave the assets to ultimately, and then you move from there. For us, it's straightforward, even though it may sound a little complicated. In terms of fees, that's really going to depend on the lawyer that you meet with. And so if, you know, I don't really want to quote fees today from our firm. That's not why we're here. We're here to educate you. We're more than happy on a complimentary basis to speak to anyone who's attending this webinar to answer any questions afterwards that you might have. The other part here will the slides, this is from Thomas, will the slides used in today's presentation be available to attendees? That'll be part of the recorded webinar. So yeah, the answer is yes. I see Barbara and Mark are joining me, so I know my time is up on the questions. And so Barbara, do you want me to just talk about the survey for a moment, or you want to do this?
Yeah, I can do it, Vincent. I want to thank you, Maria. That was a wonderful, wonderful presentation. I want to thank everybody for joining us today, but I also like you to please complete the survey. The survey will really help us to understand how we can serve you better. So if you wouldn't mind doing that, we'd really appreciate it. It's going to pop up, I believe, on the next slide. Also, if you have any questions that you think about after you're off the presentation, please, my email is there. Most of you know it. Please just give me an email or give me a call and we'll answer any of your questions. Thank you so much.
And Barbara, if I can, I just want to thank you and Mark on behalf of Marie Elena and myself, and also the Roman Catholic Diocese of Rockville Center. We really appreciate having an opportunity to spend time with you today and talk about the Catholic Estate Plan. The survey is going to pop up when the program ends. And so, yes. Okay. Thank you so much. Everybody have a happy holiday season as well.
Too.
Thank you.